Good morning, members. We have already formed a quorum, so let's start the meeting, and please invite the administration to join us.
Good
morning, ladies and gentlemen from the admin's team. I'm not going to introduce you one by one. Perhaps let's take a look of the Spain order. Mr. Yao, please. Well, mainly speaking, we will be having an article-by-article comparison with the model text. Usually we invite our DFJ colleague to do this, but today she has a sore throat, so let me try. Yes, please. The title, a slight difference. This is because Spain is of the opinion that it's not between two governments, but rather between two places. Sorry. Let me say this. We are on paper CB bracket 2 339/13 to 14 bracket 05 Annex B. All right, please go on. It's an article by article comparison. The title and then the preamble. Well, it is a little bit different so as to highlight that the requirement for authorization applies to Hong Kong only and not to Spain. Article 1, Scope of Assistance. Paragraph 1 is identical to the model text. Paragraph 2, just some slight variations. First of all, omission of reference to letters rogatory. You will find the same in many other precedents. Second, for subparagraphs G and I, they have been incorporated into subparagraphs C and J respectively. And then addition of new subparagraph I. This is about exchange of information relating to criminal acts and institution of criminal proceedings. You can have further discussion about it in Article 18. Subparagraph J, inclusion of a general provision here to comprehend other forms of assistance, not inconsistent with the law of the requested party. Paragraphs 3 and 4 are the same. Article 2, central authority. Paragraphs 1, 2, and 4 are identical to that in the model text. Paragraph 3, as the central authorities may change to provide for such a possibility, we have paragraph 3. Article 3, grounds for refusal. Paragraphs 1A to F, substantially the same as those in the model text. Paragraph 1G, the restrictions are applicable to certain compulsory measures. Paragraph 2. Would you like to sort of elaborate on this point? 1G. Well, it must be an act. The act constituting a criminal act must also be an offense in the requested party. If it is not, but it involves compulsory measure, say, for example, the confiscation order or the provision order, which are compulsory measures, then the request should be turned down. Paragraph 1G of the agreement. I'm afraid I don't quite understand. You compare it to Article 3.1H. Please illustrate with an example. It seems that I can't really understand this point. There are a number of compulsory measures in the ordinance. So when there are compulsory measures, we have this double criminality. That is, if the request involves compulsory measures, it must be rejected if it doesn't amount to double criminality. Well, for other agreements, it will still be allowed even if it doesn't reach the threshold of double criminality. For 525, basically it must be compulsory measures. It must be double criminality before you can have the compulsory measures. So for Cap 525, we have got this already. But then, for other agreements involving other countries, this is not being stated. But then Spain is rather anxious about this, so it has been included. All right, I get it. Paragraph 2. Spain has asked for the following. That is, there should be reference to terrorist offenses. And then for offenses excluded from the category of political offenses by international agreements, must also be referred to. Is it simply a matter of reference or whether it is being allowed by the laws of Hong Kong? In other words, for offenses excluded from the category of political offenses by international agreements, do we allow for the extradition? Basically, for political offenses, there isn't a definition. We have to depend on case law. So we rely on case law instead of the statute. So under different circumstances, it may be regarded as political offense. And so Spain would like to highlight this point. In Hong Kong, for the time being, we haven't got such cases. Yes, I understand your point. We don't have it in the form of statutory provisions to talk about offenses excluded from the category of political offenses by international agreements. Our law has been changed in such a way that we can extradite them. Do we have such an amendment or not? Have we? You mean the law? Well, the law hasn't. The law says that if it is political in nature, then the request has to be turned down. But what is being defined as political offenses, there isn't a definition in our law. So Spain is saying that for political offenses, they should not be grouped under terrorist offenses. And then for offenses already excluded from international agreements, should also be involved. I want to know about the implications. Say, for example, a person has breached the law in Spain and regarded as terrorist crime. He escaped to Hong Kong. Now, Spain would like to get him back. Of course, first of all, there is a request to the Hong Kong SARG for assistance. They ask for assistance. Of course, first of all, there are compulsory measures. And then that person is in Hong Kong, and then that person submits that it is a political offense. Now, as a result of this agreement signed, at least the other party may request the Hong Kong SARG. But at the end of the day, since compulsory measures in the court would be involved, so it is up to the court to decide whether the act is regarded as a political offense. Have I got it right? Let me clarify. This is MLA. Do you mean that the person invokes MLA and he claims that he has been prosecuted on a political offense? Terrorist offenses are not being included, so the court will take into account this point. My question is, if this has not been included, they would like to highlight this, so it has been included. For other agreements without highlighting this point, what is the scenario? Does it mean that the requesting party may still make such a request, or would it be disallowed? For other agreements, we did have the experience of excluding certain offenses from political offenses. Say, for example, in the case of a murder of a head of state, well, if the agreement is silent on this, there's no exclusion, then there's no way that you can put in a request. No. Now, if you claim that it is a political offense, then in fact we will look at the case law. We will have it decided by the court. Political offense is not being defined. It depends on the circumstances. In other words, whether we have it written down or not, there is no difference. Spain feels that terrorist offense. No, I would like to look at the legal implications. Having it and not having it, would it result in a difference? In the case of the court's interpretation, the government's understanding, yes, there is a difference. After it has been specified, there must be a difference. In other words, having it written down would mean that maybe the court would also consider the content of the agreement and interpret what is meant by political offense. Is that really the case? Can I confirm with our legal advisor? For our MLA ordinance, I think our laws will be interpreted by the court when it comes to political offense, rather than depending on any agreements signed with other governments. I don't think it should vary as to whether an agreement has been signed to exclude political offences. The law that is silent on what is meant by political offence, but then in our law there is the mention of political offence or offence of a political nature. I just simplify it. So in other words, this is the terminology of our local law, and it will be interpreted according to the local law. Now, you are saying that since the agreement has highlighted this point, it will influence how the court is to interpret offence of a political nature. And it will be different from other agreements. When the case goes to the court, all circumstances will be taken into account. One being that in our agreement with Spain, there is this reference. All right. What about our legal advisor? What is your view? Would you say that as a result of this agreement, our court would interpret the act as to whether it is a political offense. Would it be sort of affected, and so it will be different from other cases, the same act, but then the agreement may not have the same reference.
In clause 2 there, in fact, it goes into deeper discussion concerning 3.1b as to what constitutes offense of a political character, and it does not include terrorist offenses. If both sides have signed on the agreement agreeing to this clause, then that would reflect the intentions of both sides. Well, of course, that granted. But let's say if the person who opposes MLA at the court is in Hong Kong, then his predicament in paragraph 232 of the Spanish version, would the court's interpretation be the same, with or without these wording? I believe the intention was narrower, and that is the definition of 1B was made more narrow. That would be the two governments, but what about the court in its interpretation? In our MLA ordinance, would it affect the court's interpretation of the MLA ordinance? You understand what I mean? Yes, I do. Well, why don't you go back and think about it? Now, this is key, I would like to tell the administration. If there is impact, that would mean whether we put this in or not vis-a-vis another government will have significant impact. So would you please go back and think about it and let me know? The other colleagues, my colleagues, you understand this key point, yes? Yes. I'd like to clarify one point. For political activities, or rather political offenses, would the court be the seat to decide what constitute political offenses? Because you have now included terrorist offenses. Well, terrorist offenses is not included in the exclusion under political offenses. But what constitutes political offenses? That is decided by the court, yes? That will be decided by the court. There is no definition as such here. Is that the meaning here? That's exactly my question there just now. Let's say Hong Kong and Spain or some other country. Well, it says here on the Spanish version that there is a political offenses, but in another country there is no such wording. At the end of the day, the court will have to decide on the offense, on the nature of the offense. And my question was, would this affect the decision of the court as to what constitute political offenses? And I asked that question of our legal advisor. She has to go back and think about it. Basically, we have to have a policy, or do we have a policy to allow the government to continue negotiation? Do we or do we not specify in our ordinance this particular point? If we add this to the ordinance, would it make it clearer, or would it make it more narrow? Well, it would narrow the scope of political offenses. So the mutual aid, in a sense, the mutual assistance would be wider. That is to say, the part that we cannot provide assistance on would be wider. I understand it in the reverse way. Terrorist offenses being added into the reference is very specific. Well, usually political offenses would not be given assistance, but what about Political offenses, right. And that's for political offenses. But terrorist offenses would be... No, political offenses will not be given assistance. And what would be political offenses, we have basically made some exclusions for them to be given assistance on. Yes, clear. In Article 4, which is on the determination of essential interests, Spain submitted that this is unnecessary. The Hong Kong side also agrees that it is for the requested party to determine what its essential interests are. So that is not controversial. Paragraph 3 relates to the death penalty offences, and the request on the Spanish side, this is to reflect their legal position. This ground is now a mandatory one. This is for death penalty offences. Hong Kong no longer has the death penalty. Yes, indeed. But when Hong Kong is the requesting party, would the other side provide assistance on such instances? This would apply. On the other hand, if the other side is the requesting party, but Hong Kong does not have the death penalty, then can you please be detailed? I did not get that. I'm new to this panel, so can you please go into the details? Let me just explain it this way. Because she is suffering her throat, really. So if I can just help to explain. According to my understanding, administration, please amend if I'm wrong. The death penalty is something that they cannot give us assistance on. In another manner of saying, because Hong Kong does not have the death penalty, and if there is a person who has made an offense in Hong Kong and escapes to Spain, and Spain would not, because we have the death penalty, they would not deny us assistance, because we do not have the death penalty anyway. But on the other hand, if, let's say, if in the future Hong Kong, for whatever reasons, social changes, etc., there are certain offences which are punishable by death. There's none such now, but let's say in the future there were to be some. Then with this agreement, the counterparty can refuse assistance because of the death penalty that is honoured in Hong Kong. Paragraph 4, again from the Spanish side, added in response to proposal from the Spanish side to reflect their position under their law. This is a discretionary ground, and Hong Kong has no objection. What's the import of this? What is this about life imprisonment? Yes, if the offence is punishable by indefinite imprisonment or life imprisonment, this can also be discretionary. Now, that is very strange. This is new, isn't it? This is a discretionary ground. Now, let's say there's a murder attracts the life sentence. Are you saying that they can refuse assistance on discretionary grounds? Yes, that is the import. Now, that is indeed odd. Yes, the structure is such that we have to follow the requesting side. Yes, and that is their law. But if we think of another scenario, there is a life sentence meted out in Spain. The convict or the person, I always get it wrong, this person comes to Hong Kong after having committed a crime which is punishable by indefinite or life imprisonment, and Hong Kong is to provide certain legal assistance. Because we do have the life sentence as well, we can, on discretionary grounds, refuse assistance. What is the policy of the government on this? Is there a specific policy on this? According to our 525, according to our own legal assistance ordinance, there is none such. But in discussing with Spain, we thought that this is not objectionable on our side for there to be this discretionary ground. Well, I can understand the court will have that discretion, but in our agreement with them, the government will have this discretion, right? And vice versa. That is, the Spanish government would also have this discretion. So in the first place, you would not even bring this to the court. Is that right? The government, since it has this discretionary power, would not even refer this to the law courts. Is that right? Right. And whether you actually, what is the policy governing the use of this discretionary method? We follow the agreement. If there is this provision in the agreement, we will follow as such. Well, it says discretionary ground. What is a policy for Hong Kong in considering the discretionary or the discretion? Yes, I think this we may be interested, this panel. There may be a basket of reasons, and I would like to know what the basket of reasons are to inform your policy, or whether there is a policy. So rather than to refer to nothing as it is, and this being so odd, this paragraph, would you please give us more information? We go to paragraph 5, which is equivalent to paragraph 1G in the model text, although it has become a discretionary ground for refusal. There are precedents. So this is there are precedents in earlier agreements. The other paragraph 6 to 8 are identical. Article 4, form and language of request. Article 5, Article 4 is equivalent of Article 5.1 of the model text with modifications to suit modern means of communication. Paragraph 2 of Article 4 is equivalent of Article 5.4 of the model text. I understand. I would like to know that for the modern means of communication is acceptable, but at the end, the person will have to appear in person. Is that right? Well, let us look at Article 4. Article 4 says that requests shall be made in writing. In urgent cases, requests may be submitted by telex, fax, electronic mail, or any other means capable of holding a written record, but shall be confirmed by the original documents within 10 days thereof. So where it is urgent, there can be fax, electronic mail, telex, etc., but the original documents will have to be submitted. So according to this, it is not illegal to provide the original text. But actually, we will not be able to provide that document within 10 days. So what you're saying is that you will not be able to complete that in 10 days. So what you're saying is that for the original copy, which will be submitted within 10 days, and you'll probably start processing then, and whatever you receive beforehand, before the 10 days, you'll not have enough time to process that. That's right. Article 5, contents of request, is equivalent to 5.2 of the model text, although it is split in 2 separate paragraphs for improved presentation. Article 5.2d has been added to include other information not identified in the subparagraphs. Article 6, execution of requests, and it's identical to the corresponding article, and 5.3 as well, and paragraphs Paragraph 1 of Article 7 of the model text on legal representation has been omitted at the request of on the Spanish side under the civil law system, as they will always represent the requesting party. There is no objection here. Confidentiality, Article 8. It's the same as the model text. Article 9, obtaining evidence, documents, articles, and records. Same as model text. Article 10, obtaining voluntary statements of persons. The word voluntary was inserted because a person will have to be on a voluntary basis in making the statements. Article 11, requested by Spanish side to allow video conference testimony giving. Article 12, service of documents. 1, 2, 4, 5 paragraphs are the same as the model text. Paragraph 3 has been requested by the Spanish side to be omitted. Article 11 concerning video conference. Will this become part of the official testimony? Or is this just for background provision? No, it will constitute part of the official testimony. This is on a simultaneous basis, the court proceedings, while the person is outside of the country. This is court. This refers to the court, yes? Yes. Yes, we are still amending our ordinances, but in Spain it is already applicable. So, when we have changed our ordinance, this will be made possible. Is that right? Yes. Article 12, from paragraphs 1, 2, 4, 5, which are the same as the model text, paragraph 3 has been omitted at the request of the Spanish side.
What about paragraph 3? It is said that they haven't got the capacity to discharge the obligation. Please bear with me for a moment. Article 12(3). If I may read it out. A request for the service of a document pertaining to an appearance in the requesting party shall include such notice as the central authority of the requesting party is reasonably able to provide outstanding warrants or other judicial orders in criminal matters against the person to be served. This has been taken out in a number of agreements. The same has also been omitted. How come that they don't have the capacity to do so? I find it odd. No, they are not able to do this. So we have to take this out because they haven't got the capacity to do so. Yes, it is a fact that they haven't got the capacity, you have told us, but I found it odd to find that they are not able to do this because for an outstanding warrant, I assume that it must be in existence. Otherwise, there is no case for a need for mutual legal assistance in criminal matters. I just find it difficult to understand why they aren't able to do so. Please also reduce it to into writing. Yes, we'll check the negotiation records to see if we can identify the reason. All right. Article 13, publicly available and official documents. Basically the same as the corresponding article in the model text, except that we have added a sentence at the end. The Spanish side has asked for an additional sentence to be added. That is, the requested party shall not be obliged to reveal the reason for refusal. Does it mean that you don't need to do anything at all? Well, there's in relation to official documents. Indeed, official documents, we can't tell what actually is being termed as official documents. The scope can be wide. So if you're uncooperative, it means that nothing can be provided and then nothing can be done. So by having such a sentence, the other party may always turn down our request simply on the ground that it is official documents. Well, this involves both publicly available and official documents. For publicly available documents, we'll do our best to provide the assistance. For official documents, once it is included, of course, we would like to provide help as much as possible. But Spain would like to be given a safeguard. But then the safeguard covers too much, so much that they can refuse to do anything at all. Yes, a bit odd. Say, for example, in the case of Lai Changxing, is a case between Canada and PRC. If something similar happens to us, then the Spanish government may say that this is the ground of refusal, and then we'll be stopped. I'm not sort of criticizing Canada. I'm simply illustrating my point. Now, say, for example, we would like to extradite a particular person to come back, then Spain, if the Spanish government is not to provide any official documents, that means the whole case will be stalled. Yes, I appreciate Mr. Leung's concern. However, when it comes to MLA in criminal matters, the purpose of signing an agreement is to show our desire on both parties to render assistance. But generally speaking, the signing parties would like to be given a discretionary power. It isn't just a discretionary power, the power is too great, because a very simple document will still be regarded as official documents, and then they can cite this as a ground of refusal. Would you like to explain the matter, our legal advisor? When compared with the model agreement, the newly added one says that if assistance is refused, the requested party shall not be obliged to reveal its reason for refusal. In other words, there's no need to explain the refusal. Perhaps the government can confirm whether this is the case. The model agreement has already got this. We are just adding a sentence to say that there's no need to reveal the reason. The model agreement already says that the requested party does not have to provide the assistance. So the local law enforcement agency doesn't have to provide that to us. I don't know whether it is a matter of my understanding or not, but then it seems that the powers are great. We asked for a document. Now they're saying that no, they're not giving it to us, and then they don't have to give a reason. Allow me to read out the relevant paragraph. The requested party, at the request of the requesting party, may provide copies of any document, record, or information in the possession of a government department or agency, but not publicly available to the same extent and under the same conditions as such document, record, of information would be available to its own law enforcement and judicial authorities. If assistance stipulated in this subparagraph is refused, the requested party shall not be obliged to reveal its reason for refusal. All right, I understand it. Let me try. Now for the model text, they have got Article 13 with 2 subparagraphs. A says that information available to the public must be provided. Now, if information is not available to the public, but then this may be provided. Do not properly available. This may be provided. If it is not provided, no reason has to be given. Let me imagine, say for example, had there been an agreement with another party following the model text in the same way, then according to paragraph B, we may ask the requested party to give a reason. Now in this case, they can refuse to give a reason. So may or shall give reason would cover the same scope. Now they would like to play safe. If they don't provide it, then that's the end of the matter. If we try to ask for a reason, and in this case there's no need to ask for a reason because certainly they will not give a reason. Well, in fact, we are not denied the right to put the question in any way, but they can come back in an answer to say that they don't need to give a reason. But of course, they can always give a reason. Of course, I understand, but we can always ask, but they can reject our request. They can point to this paragraph. I think it's a matter of the right to information. Even if we are rejected, we want to know why. And then if a reason is given, we'll try to pore over it and try to see if we can try further. Now, in this case, it means that that's the end of it. They say no, and then that's it, full stop. Well, you have to be clear about this. Now, if the documents which would have been available to the law enforcement agencies, they would provide it to us. Now they try to play safe, and to a great extent, if they determine not to provide it, they do need to give a reason. Sorry, speaker, it's off my. I didn't take part in the negotiation, but I think for Spain to come up with such a safeguard, I think for documents not available to the public, probably they involve confidentiality. So probably if it is regarded as confidential, and because of the confidentiality, they don't provide the document and they don't want to disclose the reason. Probably that's the rationale behind this. Of course, it's difficult for me to cite an example, but probably Spain has this scenario in mind. I think we can understand what this is about. As to whether you accept it or not is up to you. Article 14. Yes, we are already on Article 14. Assistance in the requesting party. So corresponding to the article on transfer of other persons for paragraph 1 and paragraph 2, we are inviting the relevant person to provide assistance to the requesting party. For the requested party's duty, the duty simply is to relate the response. So it's a matter of invitation. It is entirely voluntary. Article 15. Temporary transfer of persons in custody is identical to that in the model text. Article 16, immunity. Sorry, Article 14 too. It is said that there is a variation simply to inform the requesting party of the person's response. Wasn't it the same? Well, originally, the requested party has to be satisfied that the requesting party will make satisfactory arrangements about the safety of the relevant person. Article 16, bracket 2. Who indeed shall request the person. We can't help it because it is voluntary in nature. It is just obvious. In a moment, I'm going to talk about the exemption. If the person is asked to give evidence or to provide other sorts of assistance, there will be certain immunities. Of course, otherwise he won't accede. Article 16, the title has been changed, but then the content is the same. It's now called immunity. The paragraphs are more or less identical. Article 17, search and seizure, identical to the model text. Article 18, exchange of information and institutional proceedings in the requested party. This was included at the request of the Spanish side. The party, we do not query this because this is about spontaneous submission of information. This has been found in other agreements as well. So what is the limitation? What is the restriction? Is it subject to the law? Would it be regarded as criminal intelligence? Similar to exchange of intelligence between the law enforcement agencies is voluntary. Either party may, without prior request, submit information or evidence to the other party with a view to the institution of criminal proceedings in that party. Well, I'm sure there will be certain restrictions, but then it doesn't say subject to the law of the requested party. But then it's not upon request, it's spontaneous. All the more, say for example, for spontaneous submission, would you include information arising from compulsory measures or mandatory measures? Well, there's this overriding principle, that is, it must always be subject to the law of the requested party. You mean Article 6? Article 6 of the agreement, according to the law. So there's the overriding principle. But then this is a request. But then this is a spontaneous submission. No request will be made. So it can be outside the law. Do you understand my point? For 6.2, a request shall be executed in accordance with the law. Now, there is no need for a request. It is a case of spontaneous submission.
But of course, we will have to act according to the Hong Kong law for our enforcement agency. But this is too complicated. When you say following the laws of Hong Kong, what information do you provide? Let's say we have a case where there is public information, that's fine with that. But if there is information that you have obtained through search, etc., what about those? Yes. When requesting for the search warrant, you would have a certain usage prescribed. If this is outside of the prescribed usage, well, let me just say, I do not want this to be a spontaneous exchange or that extends outside of the Hong Kong laws. Now, if you're saying that there is information involved which is obtained through search by warrants, then I think I have a problem with that. Let's say if there are further information, then there would be MLA, but rather than to say that because there is an MLA, that all the information will be spontaneously submitted. I think that we have to state all this, otherwise there will be a loophole where everything, all information will be supplied. And I hope the administration can give me a written response to this. Yes. Article 19, proceeds and instrumentalities of crime. It's equivalent to the model text. Paragraph 1 is substantially the same. Paragraphs 2 and 3 identical. Paragraph 4 is an elaborated version of the corresponding provision, and paragraph 5 is a definition provision. Article 20, 19.5. You go into details to explain proceeds and instrumentalities of crime. In the Hong Kong law, is there something very similar or not? Yes, there is. And also, I'd like to know, for Article 19, paragraph 5, A and B, would it extend, in effect, extend the scope of our ordinance? I know there were precedents, but every time our angle and the detail of our reading may not be the same. We were talking about terrorist acts, offenses. According to our laws in Hong Kong, political offenses are not to be given assistance. But you also said that in the agreement, if certain terrorist offenses are to be excluded from political offenses, then perhaps the courts, in interpreting the wording of our ordinance, may also take those into account. Now, I would like to know whether this is a similar situation for these two expressions of proceeds and instrumentalities of crime. It is in Article 30, we explain what are proceeds. 525. What is 525? Some of us do not have that text. What is 525? Read it out. .525 Roman numeral I, it talks about serious offenses and proceeds or of equivalent value from serious offenses outside of Hong Kong, and B, where these rewards or indirect property obtained from serious offenses, or where they had been encashed and have been this property had been encashed or had been transferred into other properties or values. Okay, that's Article 19(5). What about B, instrumentalities? What is that? That would be C that I read out, where the property and the value of the property connected to the serious offenses in question. All right? I understand that then. Article 20, return of documents, records, and items of evidence. Again, it is added at the request of the Spanish side. These articles and documents are to be returned. 21, 22 articles, they are the same. 23, as requested by the Spanish side, consultation concerning the actual execution and procedures. 24, same as model text. 25, application. Article 25 says that the temporal application of the agreement was included at the suggestion of the Spanish side, and there are precedents. And 26, entry into force and termination, same as model text. And that is the Article 11 of the model text. Location, identity of the persons has been omitted at the request of the Spanish side, and this is in Article 1(2)(a) of the agreement. Hong Kong has no objection to this. Yes. Let's go to the Czech Republic one. Yes, a comparison with the model text. Again, similar to the Spanish side. Scope of assistance, Article 1, same as model text except for J, and that is other assistance provided in the relevant laws. Article 2, in consistence with Hong Kong practice and provisions. Article 3, language of requests. The requesting side requests that there should be a translation. Article 1, the catch-all clause. Can you go into some discussion there? I would like to know whether this is unreasonably extending the scope. Yes, this will have to abide by the laws of the requesting party. What exactly does it refer to? Well, actually, this is exhaustive. Yes, this is already. These are all listed out. What Hong Kong can do. I mean, so this is to say, if we expand our laws, they do not have to sign a new agreement, or if they should extend their law. Is that right? Yes, this is a catch-all for that purpose. Language of requests, that the documents will have to be translated into the language of the requesting party. Yes, language of the requesting party. So we are to translate into Czech language? Yes. Oh, all right. If that is the case, there's nothing we can do about that. We have presidents. Is that right? Yes. They would also translate into English or Chinese for our benefit. Well, Are there certain countries? I mean, they're not doing the translation. We are doing the translation on their behalf. And say, for instance, the Czech Republic would request Czech language translation. Well, how do we do that? A confidential document for translation by a Czech translator. That is not easy to come by. Yeah, nothing we can do about that. But really, can't they accept an internationally acceptable language? Yes, this is a common practice internationally. Oh my goodness. What about rarely used languages? Well, you will have to deal with that. Article 4, refusal or postponement. And postponement had been added. This is the same as the text. Is it in the model agreement, postponement? No, this is added. Reference to postponement is added. What does it mean, postponement? So that is falling short of an outright refusal, postponement, delaying it. What is a postponement? Well, I'm looking at 4(4). If the requesting party's legal proceedings is affected, then a request for postponement will be made. Well, that is quite clear. So the postponement until after the legal proceedings of the requesting party had been completed. But there is no indefinite postponement, discretionary length of postponement. No, none such. So this is the only clause on article on postponement. Well, at a glance, yes, the article reflects, the title reflects the content of the article. Yes, but the model text does not have this concept, it seems, of postponement, or is it there? Well, it's different. Refusal, it's actually refusal or limitations to compliance. There is no general postponement, but it doesn't say for what reasons. So are you asking whether there are other postponement description or clauses? No, there are none such. I'm really just referring to 4 here, Article 4. 4(4) is quite clear. 4(5), let me see, also refers to postponing assistance. It's in the model text. Oh, so they're just following the model text? And the model text does not have the title of refusal or postponement? So this is just the description in the title. It's not the content. That is correct. That is fine. Yes. Paragraph 1D, the sex or the gender. If the gender puts the person in a weaker position, that is the scenario that is considered. And 1E, concerning possible inhumane treatment. This is in accordance with the human rights obligations. And Article 5, requests, again, the fax is acceptable. The request to be sent by fax is acceptable. This is acceptable to us.
Paragraphs 2A, B, F to H are substantially the same. Paragraphs 2C and E corresponding to the 2C and E of Article 5 of the model text. What about 2D? what the request should include. The identity of a person if known by whom the offense is alleged or suspected to have been committed. That's about the content of the request. Article 6, execution of requests, the same. Article 7, representation and expenses, the same. Paragraph 2 has been expanded to cover fees of receivers and extensive reproduction of documents. Article 8, limitations on use of information. Paragraph 1 and 2 are the same. Paragraph 3, added at the request of CR. For the use of information, it can be extended to certain purposes specified. Say, for example, the other procedures in relation to the the legal assistance. No, I don't quite understand. How come that it can be used for other purposes? What other specified purposes can we think of? Are you saying that the new one is 3B? No, 3. Paragraph 3. I can understand 3A. For use in other proceedings relating to the same criminal matter. What is meant by the same? Not the same case. The same criminal matter, but other proceedings. For criminal matter, under MLA ordinance, there is a definition to talk about prosecution, investigation, and other related matters. Say, for example, confiscation. So the same criminal matter refers to the same case. What about 3B? I'm a bit concerned. It says, well, it was supposed to be used for a particular investigation or prosecution. Now, under 3B, it may also be used for the prevention of serious crime. Why should we want to agree to this? This is upon the request of the CR. The use will still be subject to certain limitations. First, relating to the same criminal matter. No. It is also used for the prevention of serious crime or a serious threat to public order or with the prior consent of the requested party. There are 3 requirements. No. For 3B, it has come as a surprise. For 3A, we already know what it is used for. Now for 3B, they may say that it so happens that it will be useful to them. In other words, there will be no more safeguards. For political offenses, we are not going to extend our assistance. Now, they may name a particular offense which is not political in nature, and then they will say that it is for the prevention of other crime, and yet we may think that though they regard it as a serious threat to public order, but in our eyes we may regard it as an offense of a political nature, and in this case we'll be losing all the safeguards. It may be detriment to a particular person. So, all out of a sudden, they will invoke 3B. For 3C, now, you can guard against by passing the limitations, and you say you don't give consent. They may say that they want to use it for a particular use, and then you say that had it come in the form of a formal request, the court in Hong Kong would not have acceded. Then you can say no by invoking 3C. But then it is a matter of or 3A or B. So if they explain to you and tell you about the nature, then it means that you have to say yes, and that means there is a big loophole here. Similar provisions can be found in the agreement signed with the USA. If the information is already publicly available. No. This isn't something available to the public. This is the evidence or information which may not be publicly available. What I mean is that for the agreement with the USA, we have got something similar. No. Just pause there. First of all, please check whether you have the identical wording under Article H3B. And secondly, how can you prevent the provision being abused? Had they put in a request formally, it would have been rejected, and yet they may try to abuse this particular subparagraph. And they do need our consent, because if our consent is needed, they can have 3C. At least we can act as a gatekeeper. But then for 3B, it is not the same. So please explain how we are going to have some safeguards and it won't be abused as a loophole. To me, if there's no agreement, then there's no agreement covering this. If I consent and if others make their own decision, I'm afraid that this will become a precedent. Well, it isn't just with the other countries. It can become a precedent in relation to our arrangements with the mainland. We have a very vigorous framework, and everything is interrelated. Now, you allow this for a particular. If you allow this, it will become a very risky potential. It will become very dangerous. So please explain. Do you mind if I give you something in writing? Well, on the face of it, I'm really very worried. So please be cautious. Don't let it happen again. Yes, please. It will be expanded to uses not for the purposes of the request. You say that this is in line with the spirit of the agreement. How can you link the two together? Mr. Yao, for the specified uses, that's in relation to 3 items that we have just taken up with you. Not specified in the request. Why are you saying? Well, there are 3 points here under H3 for use in other proceedings relating to the same matter for the prevention of serious crime. For the specified uses, why are you saying that you're satisfied that they will be confined to the 3 of them? Have you specified that they must be either of them, one of them? Yes, under Article 8(3). Let me tell you about my observations for H3B or even H3C. For H3C is easier because the government has to be accountable to the public if we have got an outrageous case, they use the information and then it is exposed. So you would be careful when you make the decision to give consent. But then for H3B, as long as they think that this requirement is met, then you can't really limit it. I would rather dispense with the entire CR order. That's the degree of my concern. Article 9. Obtaining of evidence, documents, articles, or records. The title has been expanded to reflect the content. Paragraph 1. The same as our model agreement, except that two paragraphs have been consolidated. For paragraphs 2 to 5, they are identical to the model agreement. Articles 10 to 13, the same as the model agreement. Article 14, certification and authentication. It states that there is no need for consular certification. This is agreement because neither Hong Kong nor Czech law requires such certification or authentication. Article 15 is identical as the model agreement. Article 16, transfer of other persons, same in the case of the Spanish agreement. So it is on the basis of invitation. So the requested party's duty is to relate the response of the person to the requesting party. For the rest, they are the same. Article 17, safe conduct. So for the person referred to under Article 16, he will be entitled to certain immunities. So the nature is the same as that in the model agreement. Yes, our legal advisor would like to state her observation. For Article 17, safe conduct, I have noted that for section 17, 1b bracket small 2, and also section 23, 2a, Roman small 2, it says that if a person is outside of Hong Kong, or if Hong Kong has already given assistance, and this person has been given exemption for any acts or omission, if he would be sort of prosecuted in a civil case, there is a time element mentioned that is prior to leaving Hong Kong. But then in your case, there isn't this element about the time, so please explain the difference, Mr. Yao. I think it was already asked in writing. Yes, we have already given a reply in writing. The legal advisor referred to Cap 525. There is a reference to the timing. We also mentioned this point earlier on. The request can only be executed in accordance with the law of the requested party. So in this case, Cap 525 will apply. I don't understand. You talked about the safeguard in relation to the duration under 525. Are you saying that that prevails over disagreement? Maybe our lawyer can explain. In the agreement, it says that we have to do so according to the law. So for Article 6, it says that we have to act in accordance with the law. So when we execute the request, we have to follow Section 17 of Cap 525. I'm not sure whether you are satisfied. For 17.1a, there is the element of time under the MLA order. But then for 17.1b, this is absent. Which one has got it, which one hasn't? 17.1a, we have the timing element, which preceded his departure from the requested party. For 17.1b, it is absent. I don't know whether it will have a bearing on the execution. This is entirely voluntary as to whether the witness will go to the requested party to provide assistance. So every time when we execute the request, we will get a guarantee from the requesting party. And we have to do so in accordance with Cap 525. And then it is up to the witness to decide whether he's willing to go to the requesting party to provide assistance. Well, I think the legal advisor is saying for 17.1a, you guarantee that he will not be prosecuted, and then the time, the duration would start from the time that he departs for the destination. So there is already this safeguard. But then for 17.1b, he shall not be subject to civil suit. How can we be sure that he will not be subject to civil suit? Is it because there's already a piece of legislation to do that?
I'm looking at the model text. In fact, the model text goes through all this content in one go rather than to separate it into A and B as you're doing it here, which preceded his departure from the requested parties applicable to both parts, that is, parts A and B. When you separate the two, then A would have this language and not B. Well, if that is the case, as long as a person has not departed from the requested place, party's place, there will not be any proceedings on a criminal basis. But on the civil suit, it is silent on the temporal element. So is it forever that there will not be any prosecutions forever for civil suits? Even if the person had left and gone to another place and come back, there will be no prosecutions? This is beef. When he departs from the requested party, what protections there will be? Well, I understand. What I'm saying is that, of course, if there is departure, he will not be prosecuted. But looking at the text here, if he's left that particular place subsequently, there will not be any prosecutions. Do we have that assurance? I mean, I really do not understand. Let's say a person comes to Hong Kong and presents the evidence, and after that after coming to Hong Kong, having done that, he returns to the Czech Republic. How can we assure him that he will not be prosecuted under a civil suit. We, of course, do not have that kind of ordinance. How can you enter into an agreement with another country on this basis? Well, actually, our colleague has mentioned that before we seek the person's agreement, we will ask the requesting party to give us a commitment. So this will be in keeping with the ordinance. Well, actually, there is a time element in the ordinance draft. But the Czech Republic is requesting something higher and above than what is provided in our ordinance. What is the time element as described in the ordinance, please? 17(1)(b). You can think of this scenario. A person is in Hong Kong, and this is all on voluntary basis. So what do you say to him? According to 17(1)(b), the Czech Republic will have to guarantee that they will never prosecute him, not only when the person is in the Czech Republic. How can you safeguard that? And how can the Czech Republic safeguard that? Well, I don't know. Maybe they can do it. But if we, Hong Kong, ask the Czech Republic to persuade somebody to come back to Hong Kong, provide evidence, and we cannot safeguard that this person will never be prosecuted on civil basis because of the of a certain offense. Hong Kong can never assure that, and therefore I think the model text is peculiar here. Can you please go back and think about it and come back with a written reply? Yes. Yes. Legal advisor, please. Yes, Mr. Chairman. Allow me to ask a question about a previous article. 4(1)(f), actually, because it does seem to be in conflict, or it is different from Cap 525(1)(b). If we look at Article 4(1)(f), it doesn't say if the relevant party has already been punished according to the requested party's laws, whether that person will be punished again for the same offense. In 5(1)(b), it says that the person will be immune afterwards, but it is not clear from 4(1)(f). So the refusal to give assistance had been limited in this case, it seems. Can I have a response on that, please? Yes, I have also written to the administration concerning this question. I do not understand. Can you please explain again, legal advisor? You're saying Cap 525. If a person has requested for assistance from us, but the relevant offense had already been punished and completed, then we can refuse assistance. In Hong Kong can refuse assistance. But 4(1)(f) in the agreement, there is no such element, and that is where the person had, or if the requesting party had already given out the punishment or the penalty, then then Hong Kong can refuse assistance. This is the case of double jeopardy. The requesting party would of course know whether there had been a sentence based on the same offense. So they would know whether that is a conviction. But for double jeopardy, the requested party will also have to assess whether the requested party also has the same conviction. That is, the requesting party should not already have had the conviction. This is not about conviction. It is about the penalty or the punishment. If our law does not allow, of course, we cannot provide any assistance. But in entering into an agreement, we have to be careful for something that we definitely cannot honor. And if we put that into the agreement, let's say Czech Republic and Spain had also done the same. If we do not put this into 4.1 or 4.1f, that is a problem. If I can ask a few questions first. In the model text, is this clause in the model text? I would believe so. Yes. The requested party, it says the requested party, where the person had been punished, yes, convicted, acquitted, or pardoned by the requested party. Yes. Sentence. The person served the sentence. Now, if this is in the model text, and when we discuss this with the other party, and it is also in our law, then we say that this is already in the law. So you're saying 4.1f is the same as the model text? Are you saying that? It refers to the requested party. But what is left out here is the serving of the sentence. The serving of the sentence. Well, it only mentions conviction, acquittal, and pardon. Of course, before there can be a completion of sentence, there has to be conviction first. What is 525 about? Undergo punishment. That's a wording, or have undergone punishment. That's a wording in cap 525. Undergone the punishment. If a person has already undergone the punishment, then he would definitely have been convicted. That's your point. But he has been convicted, but not served the sentence or undergone the punishment. Then there will be some mutual assistance, and if the convict is in Hong Kong, then we will provide certain information to the Czech Republic for the extradition of the convict. But if we do not have this clause, that is in the agreement, if we say conviction, but we do not have the wording here, like such as undergone the punishment, what would be the problem? What about the case when the person had undergone the punishment, then we cannot refuse him? Well, actually, in cap 525, it says that the D of J, under what circumstances can he make refusals? And one of the situations where he can make a refusal is where the person had undergone the punishment elsewhere. And if we do not put this in here, then the scope of refusal would be smaller. Well, not necessarily smaller. Perhaps there can be other stipulations that he can refer to. But the requesting party will be unhappy. Well, since you already have this in your ordinance, why don't you specify this? And that is to say, under Cap 525 situation, where there had been punishment undergone, can we perhaps still have recourse to B here and say that we refuse the assistance? Well, we refer to ordinance, to the ordinance section 5, 51E, 51E. 51E in the ordinance, but what about the agreement? Which clause are we referring to? 6.2. Yes, it can only be admissible in Hong Kong law. I really do not know what the Czech Republic's consideration is concerning this, but I think I know because of 6(2) that under such circumstances we will not be able to help you provide the assistance because of our ordinance. But in 4.1, Article 4.1, because it does have the title of requested party being refused assistance, I think we have to specify all the situations under which we will refuse assistance to the requesting party. Why is this left out? But this is the same as the model text. Is it because the model text did not reflect everything in the ordinance? I think when we set out the text of the ordinance, we have exceeded the model text, put in content that is not in the model text. But, well, I've learned a lot from you over the past years. Your colleagues may be thinking, yes, this is in the ordinance, but it is inconvenient for us to put into the model text. And therefore, you have kind of hidden it in 6.2, and we cannot spell it out. Perhaps because of legal values conflict with the other party. It is possible. But if possible, would you please spell it out and put it in? So that we have basis for negotiations in the future from with the requesting party. Yes, we can do that. For controversies, will this not bring on controversies at the point of the court's considerations? We have created a gap. Would we not have created a gap? Now, if the Czech Republic requests for assistance, then they will have to go to the court to represent their case. But if we say the ordinance says so, the court, the judge, would of course not consider it. Mr. Leung's point is that you can go try. Now, if the convictions are very clear and it's been spelled out here, and the having undergone punishment is not spelled out, would that create a gap? Now, the reason why we refuse assistance is because if there is refusal, they will appeal. No, if I can just restate your issue, Mr. Lam. You are saying the requesting party is that you're not playing fair, Hong Kong government. You have not spelled out that under such circumstance you will refuse assistance. Are you being not gentlemanly? Now that we need your assistance, you are not helping us. Then it becomes a foreign relations issue. Can the other party, the other party will not be able to bring us to court, the Hong Kong SAR government, and if our government say we just do not do this, we will not provide the assistance. But maybe, at least there will be controversy because we have not spelled out that under such the circumstance, but we are refusing assistance anyway.
We were on Article 17. Article 18, search and seizure. Search and seizure. Paragraphs 1 and 2 are the same. Paragraph 3 has been amended to add a second sentence to the effect that the requesting party may dispose of the seized property. This is consistent with the principles in the model agreement. I don't know how this can be done. If the requested party permits, the requesting party may keep the property. Just a moment, please. It's quite complicated. Search and seizure. So a second sentence has been added. All right, it means that we have already seized a property, has been turned over to the other side after court procedures. They keep it and we agree that they may keep it. So we have seized a property, say for example, something very valuable, say for example, a piece of diamond of world-class quality. Say for example, it is said that a Czech national stole it, came to Hong Kong, keep it in a safe. We opened the safe, and then through court procedures, it was returned. Now they say that they would like to keep the diamond, thinking that it is a national treasure. So we have to give consent for it to keep it. Say, for example, if that Czech national is to put in a application in our court, or if a third party, say for example, or out of a sudden an American national claims ownership of the diamond. So is it right that we won't give consent when it is disputed? You have to remember that this is quite complicated. So what sort of guiding principles have you got here? In accordance with its law, the law of the requesting party, not our law. For search and seizure, we follow Cap 525, Section 12. The DOJ may issue a directive So under Section 12, bracket 11, the DOJ may issue a directive as to how to deal with the property. He will only give directive as to how the original property is to be disposed of. There are a number of conditions. First of all, the requesting party has to give a guarantee in writing as to why the original has to be kept. The DFJ has to consider all the reasons before agreeing to have the original being returned to them. Yes, they do have 11B under Cap 525. So the DFJ can be the final gatekeeper and have it back. In other words, for Article 18.3 of our agreement, in other words, our DFJ will reserve the power to ask for the return, and they can't ask any questions. Well, I remember that for Cap 525, when the bill was enacted, I recall at the time we said that it would be risky. If we were to be careless, then we might have to bear a huge responsibility, because the property might be very variable. It might cost billions of dollars. If somebody succeeds in asking a court to rule that it has to be retained in Hong Kong for proceeds of crime, well, different parties may try to claim ownership. Criminal A may have stolen it from B. You return it, and yet it may be risky. According to the Czech laws, A got it from B by theft. But then, according to the laws of Hong Kong, we may say that, in fact, it is in the ownership of C. So if it is returned to the Czech Republic, well, where it is ruled that A stole it from B, so it was sort of producing court. Somehow, in Hong Kong, it is ruled that it belongs to C. When you exercise the power here, you have to be exceptionally careful. Our legal advisor, anything else to add? Well, I just want to caution you to be very careful, because so much is being involved. Maybe A stole it from B, but then it was submitted as evidence in the Czech Republic. But then the Chinese government may say that it has to be returned to the mainland because it is national treasure and has to be exhibited in the National Museum. Mr. Chairman, when the DFJ exercises this power, he has to be very careful. That's your advice, Mr. Chairman, right? Article 19, Proceeds of Crime. Paragraphs 1, 2, and 4 are the same. Paragraph 3. When you execute the request, you have to follow the laws of the requested party. I think this is appropriate. Article 20, Spontaneous Information. Again, added at the request of the CR. For Article 20, is it different from the earlier one that we looked at? When compared with Spain, the Spanish one, that's same. So please give a reply on both. Articles 21, 22, the same. Sorry. Limitations of use. We talked about that in the Spanish agreement. Have we passed it? The one pertaining to the CR. Passed already. Okay, it doesn't matter. 21, 22, the same. Entry into force and termination. if we are to terminate the agreement, we have to give 6 months notice. But then they're also taking one point out, that is about the service of the notice. Anything made before the service of the termination notice, the requests have to be executed and to be done in English. So have I omitted anything about the limitation of use? No. All right. We have already have an initial examination. So while we will wait for your reply, and then we'll have another meeting. Article 23, entry into force and termination. It is a bit different from the model agreement. First of all, it is not on receipt of the notice, but 6 months after the receipt date of the notice. And then for the model agreement, they have something like an application clause to say that prior to the termination of the agreement, the requests already received should be dealt with in a particular fashion. But I think this is not found in the agreement. Well, this is amended and different from the model agreement. This is a point of request of the CR. The legal advisor is right to say that for requests received prior to the service of the termination notice, we are supposed to continue with them. This is absent. But I think we have added something to cover this. That is, the termination cannot take place unilaterally. It has to be covered by 6 months notice. So even though you have talked about, you have already decided to terminate it, there will still be 6 months time. So that's at the request of the CR, different from the model agreement. For the model agreement, once a request has been made, even though the agreement has been terminated, you still have to go on with it to prevent either party being reluctant to proceed with a particular request and then say that the agreement has to be terminated owing to some very complicated factors. Now, that won't be the rule. Now you say that since there will be 6 months' time. What about if the request takes more than 6 months' time? In theory, the request has to be executed ASAP, but if they drag their feet and it takes more than 6 months, that means it will be terminated and nothing will come out of it. But of course, an agreement is an agreement. If they won't even agree to this, then there won't be an agreement. At least we know that they deal with it in a different way. Personally speaking, to be frank, if a request is so serious that the agreement should rather be terminated, then it must be a very serious matter. So I'm sure they will try to make use of other loopholes or other mechanisms to bypass it. So I think after all, it's a matter of reasonable expectation. And I won't throw it out just because of this. All right, we should pause here. We will wait for the reply from the administration. Thank you.